All right, we just finished at looking at uh, the pre-incorporation contracts, right? Right. We saw the principles behind pre-incorporation contract. We're saying that a promoter cannot be an agent of a company that has not yet been formed, right? It means that any contract that he enters prior to the incorporation of a company, he is personally liable unless the company itself, after incorporation, adopts the contracts, right? So that's the principles that we actually finished looking at. Now let us look at the formation of a company. So what is the formation of a company? So formation of a company can be defined as the administrative process involving the delivery of the company's memorandum and and articles of association and accompanying statement. So we're saying that it's basically administrative process, right? And this administrative process is just involving you taking to the registrar of companies the memorandum of association, articles of association, and any accompanying statements. So in this chapter, we'll talk about these accompanying statements. But in the next chapter, we will look at the memorandum of association and the article of association in detail, right? So what are these accompanying statements and so on and so forth, right? So in section 27 of the Act, allows a person subject to the provisions of the Act to apply to incorporate a company in any of the categories that we actually discussed in chapter 1. We actually looked at 4 categories in chapter 1. We looked at private companies, public companies, companies limited by guarantees, and state-owned companies, right? So any person can basically apply to incorporate a company, right? But it's basically subject to the provisions of the Act, right? Maybe the Act might not say that, might give sort of things, a person who is eligible. For example, a minor cannot open a company, right? So, but any other person can basically what? Open up a company, right? Open up company, but subject to any provisions of the Act. And he can open any company in any form, right? Private company, public company, state-owned, and limited by guarantee, right? But in section 28 of it, right, it states that a company to be incorporated, an application must be submitted to the registrar in a prescribed form. So you have to make sure that you apply, right? Put your information on a prescribed form and set it to the registrar's office, where he actually confirms, and now the company is incorporated. But if you cannot send the application to the registrar of companies, it means that the company won't be formed. So these are the accompanying statement that we are talking about on the definition of formation of a company. We are saying that this is basically the administrative purpose that involve sending to the registrar the articles of association, right? The memorandum of association and accompanying statements. So this accompanying statement, one of them is this application form. Application form, right? So the application must be signed by each applicant and accompanied by a written consent to act as the directors and secretary and declaration of eligibility for such position. So apart from just sending your application forms, these application forms should be signed by applicants. It can be 1 applicant, 2 applicants, and so forth, right? It should be signed. That's the first thing. It should also be accompanied by a written consent of those people that will take on the positions as directors, as secretary, right? Written consent. So it's like they are agreeing, Kuti, they will actually take on the position. We exist and we have agreed taking positions as director. We are agreeing to take on position as secretary. Right? So we have the application that is jury signed, then written consent by the directors and the secretary, right? And lastly is the declaration by these guys that they are eligible. Declaration of eligibility, right? Declaring that if they were eligible. For example, am I eligible to be a secretary of a company? We know there are the eligibility criteria for such positions. For example, you have to be, I think, a lawyer for you to take on a position like this, right? We'll look at those, right? We'll see those things, right? Like for directors, you can't be less than 18 years old, right? So you're saying, you're declaring that I am indeed eligible to take on this position. So you're saying that you are sending the application that is duly signed by the applicants. You're sending the written consent, right? Another document, right? Directors are agreeing that they are indeed taking on these positions, right? And also you're sending a declaration of eligibility, right? So these are the three things that are accompanying the application, right? The application itself. If the company has share capital, right, every shareholder must also submit a written consent to being a shareholder and providing details of class and the number of shares they will hold, as well as the consideration that they will provide for the issue of shares. So by the time that you're actually applying, there are two situations. It's either other people have already taken up shares in the company or they have not taken up shares in the company. Where people have already taken up shares in the company, then you also have to accompany the application letter with a written consent of the shareholding by these people, right? Acknowledging that they have already taken up shares in the company, right? And how much money they are supposed to pay, or how much money they have paid in terms of consideration to take on those shares, and also the class of shares that they have taken on, right? That's something that you also have to accompany these application form. So we're talking about, these are the accompanying documents, right? These are the accompanying documents. This is particularly for companies that is limited by guarantee, right? So where it is the company that is being formed is limited by guarantee, you are supposed to also accompany a document that states the specified amount of money each member undertakes to contribute to the company in the event of it winding up. We saw what it was to say limited by guarantee, right? Limited by guarantee. So every member guarantees to say that in the event the company is winding up and the company still has liabilities to pay, right? We are paying this amount of money, right? Towards the settling of these debts. So that document also has to be accompanied for a company limited by guarantee. But this is particularly important for this form of company. Let us look at what is supposed to be included in the application letter, right? The content of the application letter, the full name and address of each applicant. So you have to include that in the application letter. The full name and the address of every director and secretary of the proposed company. So you also have to include who are the directors of the company, where do they live, right? Who are the secretaries of the company, and where do they live? Details of any business or occupation and the directorship of any public company or subsidiary of a public company held by each director. You also want to say, what do the directors do, right? Details of what the directors do. Are they doing own business? Or are they directors of any public company or a subsidiary of any public company. These are supposed to be included in the application, right? The type of company that is being formed. Are you forming are you forming a state-owned? Are you forming a company limited by guarantee? Are you forming are you forming a private company, or are you forming a public company? Right? So that's something that we have to be aware of. That's supposed to be included. The registered office of the proposed company. Whenever you are registering a company, you have to have a place of business. A place of business. Kodi anthu azakupeza ndi kuti. That's your registered office. Is it in Malangalanga building, right? Is it Chayamba building, right? Is it in Keza building, right? That's the office that we're talking about, the registered office. So you have to say, where is your registered office, right? So because these are basically are legit businesses, right? You have to have this registered office, right? Where is your office? And right? That's the registered office has to be included there as well. So another thing that is supposed to be included is the full name and the address of every shareholder of the proposed company and the number of shares to be issued to every shareholder and the amount to be paid in consideration of these shares, right? So we are saying that where the shares have already been subscribed, right? Some people have already taken up the shares, subscription, right? You have to include their names. You have to include their addresses. You have to include how much shares they have taken on. And you have to include how much consideration they have paid for those shares. Right? In a case for a one-person company, then this should also be included. The full name and residence and address of a person nominated by the proposed director to be the secretary of the company in the event of death and some incapacitation, right? We looked at one person company as a private company that is owned by one person or the sole owner, right? The only person, the only shareholder, the sole investor or sole owner, right? Is also the sole director. Company director ndi mmodzi, once director yo the only shareholder of the company. That's a one-person company. Talk about in such a scenario, right? You are supposed to nominate as a person, as the sole owner and director. You have to nominate the person that will take over, right? Take over in the event that you die. What happens if you die, right? Who is going to take over, right? Who is going to take over as this company secretary? In the event that you die or you are incapacitated in any way, right? You have to include that because without this mentioning, it means that if you die, everything goes, right? There's no continuity, but you have to mention who is taking over in such a scenario. Another thing is that you're supposed to include in the application is the declaration made by the applicants that the information provided is correctly true. Very important thing to include. Are you giving the correct information? You have to declare. You have to accept that whatever information that I'm giving is true, correct. That's the last thing that you have to do. That means you sign that, yes, I declare that the information that I provide is duly true and correct. Right? That's something that is supposed to be included in the application letter. Right. Now we've looked at in detail what the application letter is all about. We've looked at other stuff that is supposed to be accompany the application letter, like the written consent by directors, right? The declaration of eligibility by the directors, right? The written consent of shareholders if it has been taken up. Right? Then now let us look at also what are the other statements. Then the other statement that we should look at or document is the statement of capital. The statement of capital. For us to understand, right, let me take you back, right? We know that prior to the current act, the Companies Act 2013, we are using the Companies Act 1984. So in the Companies Act 1984, all right, for any company that is a limited company, right, it was supposed to include in the memorandum the amount of share capital which the proposed company will actually issue out and the par value of the same. So you are supposed to include in the memorandum of association how many issues we are going to issue out as a company and what will be the face value or the nominal value or the par value of our shares. This is not the first time that we've made par value or nominal value. We've looked at it in financial accounting. We've looked at it in accounting, right? So it's just basically the value that is attached to the shares. That's the face value, right? That's the face value. For example, if we were to talk about the face value, right, we would give an example of a note, right? A bank note, right? For example, a bank note, right, of worth 5 kwaja, ma 5 kwaja kale amapepa acho, right? If you know them, they were 5 kwaja amapepa, right? What is on the face is basically the 5 kwaja. That means it's worth that amount. That's basically based on what the face. But somebody could choose to buy it, pay more for that one, because maybe Kanamba Zikusoa, right? Zikusoa, so they would just want to keep it as souvenir, right? So they would pay more, maybe 5,000 for that, although what's on the face of it is 5 kwacha, right? That's to do with that, right? So this is called authorized share capital. So authorized share capital is basically the maximum number of shares that a company was able to issue over its lifetime. So that's the maximum number of capital, the maximum number of shares that a company can issue, right? Can issue. So they had this ceiling or this maximum number, right? Which was not supposed to be exceeded, right? And this was included in the memorandum. But if you wanted to change, right? For example, it was 1 million shares. So you wanted to change to 1.5 million shares. It meant that you just had to agree and pass an ordinary resolution. An ordinary resolution, right? An ordinary resolution. So an ordinary resolution is just a resolution, right? Or an agreement, right? An agreement of more than 50%. That means 50% of the people have agreed on a particular issue. That means more than 50% of people have agreed that we should change the authorized share capital. That means that will be changed. If 49% agree, it means that it won't go through, right? So we'll look at other types of resolutions like special resolution and so on as we proceed. But for an authorized share capital to be changed, it meant that they had to pass an ordinary resolution, right? They had to pass an ordinary resolution, right? Now, in the Companies Act 2013, it abolished the concept of authorized share capital. There's no longer this limit that is supposed to be included, right? So the information about the share subscribers for the subscribed shares to the memorandum, which was earlier set out in the memorandum, right, will now be recognized in the statement of capital. Right? You no longer have to put the details of share capitals that have been subscribed in the memorandum. You will include this in its particular statement, and this is statement of share capital. So the question is, how can we define statement of capital? Right? What is the statement of capital? Statement of capital. So a statement of capital would just say that is a document that shows the number of shares that have been subscribed. Right? So it's a document that shows the number of shares that have been subscribed. Right? That's what statement of capital is. And this is sent to the registrar accompanying what? Other statement that we have actually looked at, the applications, memorandum of association, article of association. Let us look at what is supposed to be included in the content of the statement of articles. The total number of shares of the company. Each class of shares, you have to include the prescribed particulars of the rights attached to the shares, the total number of shares of that class, and the aggregate par value of those shares where applicable. So we are saying that first thing you have to put, how many shares do the company have? 50,000 shares. No, this is not the maximum, but how many shares that you have or an issue. Another thing, for each class that you have, you also have to say, what are the rights that are attached to each shares? You can have preference shares, ordinary shares. So you're saying, what are the rights that are attached to each class of share? And you also have to talk about what is the total number of shares of that class. I have 50,000 ordinary shares, I have 25,000 preference shares, and so on. Another thing is the aggregate of the par value of those shares where applicable. So if the par value of my ordinary shares is 50, it means I'll say 50 times 500, 50,000. So it will give me like 2.5 million. That's the par value of all the shares in that class. Same applies to share preference shares, right? Preference shares might be 10,000, and my par value of this preference shares is 40. It means that you just multiply, right? So it will be 10,000 shares, number of shares, times 40 as the par value. It means that I have this is the par value of that class. That's what they want us to include in the statement, right? For each class, right? Another thing that we are supposed to include is the amount paid up and the amount, if any, unpaid on each shares, whether on account of par value of the shares as applicable or by way of premium. If you have done accounting too before, right, you will know that whenever you have issued shares, for example, you're saying that the shares are worth 30 each share, the company will not call up all this money at once. They might be requesting this money in bits and bits. They might say that now on application pay 20, first call pay 5, and second call pay 5. So they're saying that whenever you're sending, you should include how much money have already been paid and how much money have not been paid on those shares, right? In case you haven't called up all the shares or the money at once, right? So that's another thing that you are supposed to include. The amount that is being paid up, the amount that has not yet been paid also has to be included there. Let's look at another statement, which is the certificate of incorporation. The certificate of incorporation, you should look at it as the birth certificate of the company. Birth certificate of the company. Right? Mwana kabadwa, you give it what? Give him a birth certificate. Company kabadwa, you give him a certificate of incorporation. Right? So in section 29 of the Act, it provides for incorporation, right? So where the registrar is satisfied that the application of incorporation of the company complies with all the regulations, all the acts, all the provisions, right? The registrar is required, upon payment of the prescribed fee, to enter the particulars of the company in the register, assign a unique number to the company as its company number, and lastly, issue a certificate of incorporation in the prescribed form. So this is basically after the registrar of company is satisfied that the application of incorporation is complying with all the provisions of the Act. That means he's satisfied that everything has been done correctly, every information has been brought. Now, he can now basically do these three things, right? First, make sure that he writes the company in his register, that means in the database. Give him a unique number, right? This is basically the number that the registrar will recognize the company with, right? Instead of their name, right? They might they'll be recognizing him with this unique number that is provided, right? Unique number that is provided by the registrar, and it's unique for each company. It's unique for each company. And lastly, issue a certificate of incorporation. So this certificate of incorporation is the one that we're referring to as the birth certificate of this company. So the question is, what would you say a certificate is, right? Certificate of incorporation. Because, right, there's no definition, right? We could come up with our own, right? So you could just say that is the birth certificate of company, right? It's possible, right? That one is basically telling a person who is a layman. But you could say the best definition would be that is a document given after the registrar is satisfied that the application complies with the law. The application of incorporation complies with the law, complies with the act. So it is a document given after the registrar is satisfied that the application is in compliance with the law regulation, right? So basically that's it, right? That's it. Now let us look at the concept of conclusiveness of certificate of incorporation, right? The conclusiveness of the certificate of incorporation, right? So what is this all about? So with this principle, they're saying that a certificate of incorporation of a company is issued is conclusive evidence that all requirements of the Act as to incorporation have been complied with, and on and from the date of incorporation, the certificate, the company is incorporated. So what they're saying is that by you having the certificate of incorporation says that it is evidence enough or sure evidence. That's basically conclusive. It's sure evidence or evidence enough that you are saying that the company has been registered and has satisfied anything to do with the compliance with the law in terms of what? Incorporation. By having that, that's just evidence. Now, everything has been complied with, right? Has been complied with, and that company is duly registered, right? So by having the certificate of incorporation is sure evidence or is enough evidence to say that or to conclude that the requirements of the Act in terms of incorporations have been complied with. And from that date, that company is an incorporated body, right? That's to do with conclusiveness of certificate of incorporation, right? So this means that even if subsequently discovered that the formalities of registration were not were not in fact complied with, the registration will not be held invalid. So what it means that, for example, tunaona kuti what are the contents of an application, and akamona kuti you have to what? Declare that your information is correct. So for example, by declaration by suna saine, right? You haven't declared that your company, right, that information is correct. But the registrar, he may be former or whatever, still thought that everything is correct and still gave you the certificate of incorporation. Certificate of incorporation. By giving you this certificate of incorporation, it means that despite kuti panama irregularities enake, right, this company is still in existence, right? It's still in existence. So kuti mungamanira kuti company faki sana sene jina yake, right? Sana sene jina yake, right? It means that the company is no longer there, right? It wasn't incorporated. No. What the registrar would do would just require you could come and sign that the information is correct. Right? Just rectifying those irregularities. But otherwise, the company, after being issued a certificate of incorporation, is evidence enough that everything was complied. Right? So any irregularities that are there will not, in law, right, make the incorporation invalid. Will not make the incorporation invalid despite those irregularities, right? That's what the conclusiveness of incorporation is all about. So the reason for doing this is just to make sure that we are protecting third parties, right? We are protecting people that are dealing with the business, right? So the reason of this is that once the company has commenced business and entered into contracts, it would be unreasonable to void the contracts because the procedure defects in the registration of the company. Imagine muna kuti simuna saini ichocho, right? And you start dealing mabweka drama ku bank kena mukanika kupereka ine mkungula kuti tazitakumbukira kuti pena pake sina saini because company mene was not existent, nakuti if we were not in existence, that means we are not liable to pay the bank. No. Amaopa zimene zonso, right? Because you have already started entering into contracts, right? They want to make sure that parties are not unfairly, right, treated in that particular scenario, right? So because of that, all those defects that are there, right? Because everyone that was entering into the contract, by looking at the certificate of incorporation, Chile concluded that the company had complied with all regulations of incorporations. So it would be unfair and unreasonable to make those contracts to be void. So the affected parties can at any time request the registrar to remedy the defect in the registration. So what happens is that you just have to make sure that you resolve those defects in the registration. For example, simuna saine pena bake, you just go ukasaine kwa registrar, simuna bake document inasi does not affect in any way the incorporation of the company. So that's what the conclusiveness is all about. In other words, certificate of incorporation is enough proof of existence of a company. And lastly, let's look at the legal effect of the certificate of incorporation. By having the certificate of incorporation, what does it mean? Right? By having this base certificate, what does it really mean in law? So Section 32 of the Act provides that a company incorporated under the Act is a body corporate. The term body corporate just means that, right? Just means that it is a legal person, right? Meaning that it can be sued or can sue in its own name, can hold its own assets, and so on. It assumes a legal personality. That's what it means by a body corporate, right? So by incorporation, what it means is that the company is a body corporate with the name by which it is registered and continue to exist until it is removed from the company. So you are going to be in existence until you are removed from the register. That means the company has wound up and the company has been liquidated, right? Unless that, right, you are in law a person, a person in law. You are not a physical person or a natural person, because a natural person ni muntu ngati ineyo. But this one is basically called a legal person, right? But lamulo likuvomeza una kuti munthu uyu is a standalone individual in law. Sukuti ndi munthu wamoyo, no? But in law, they will treat this corporate body as a different person from any other thing, right? That means it can hold its own assets, it can hold its own properties, and so on and so forth. It can be sued or sue itself. We'll look at this in more extensively when we look at chapter 4, which we will look at the case of Solomon versus Solomon. Right? Solomon versus Solomon. Right? Solomon versus Solomon. So, this means that from the date of incorporation mentioned in the certificate, the subscribers to the memorandum, together with such other persons as may from time to time become members of the company, become a body corporate by name contained in the memorandum, capable forthcoming to exercise all functions of an incorporated company. So the moment that the company is given this certificate is already a corporate body, it can actually exercise all the function. It can sue or be sued. It can actually own its own asset, go into contracts, and so on and so forth. Right? And so on and so forth. That's basically to do with that. Right? That's basically to do with that. Then the question is, so if it is an own person, why have the directors to run it, right? Because as I said, it's not a natural person, right? So it's like, it doesn't have life. So it means that it is sort of an incapacitated person, right? Incapacitated person. It cannot do things for itself. So it needs somebody, right, to actually help them do things. It means that these directors are basically the mind of the company, right? Helping them to make decisions. But otherwise, in law, a company incorporated is a corporate body. So that's something that we have to be familiar with, and that's the end of the chapter. Thank you.